Roger, thank you so much. And thanks also to David, to Hiroshi, to UCLA, to USD for putting this event on. Christina and I will speak just briefly about the book, and in order to maximize the time for Hiroshi's response and a conversation with you all. We'll divide up the conversation, I guess, as follows for ourselves. Our book is really about two things. You know, it's about how the president became our immigration policymaker-in-chief. And it's about what that means for the present and future of American immigration policy. So I'll start by talking a little bit about that first question, the question of how we got to this place in the world where the president wields so much power over immigration policy. And then I think Christina is going to talk a little bit about the more normative questions that descriptive project raises. You know, the question whether we should be happy or terrified about the role that the president's playing. So just to set the stage, I should note, you know, presidential control over immigration policy is everywhere we look. You know, you can see it in President Trump's ban on migrants from majority Muslim countries, on his administration's attempts to rescind the DACA program, which was itself a signature executive branch initiative from the Obama administration designed to protect dreamers from deportation. And you can see it most recently in the near complete shutdown of America's system for screening asylum seekers along the US-Mexico border. So all of these recent events make it really tempting to think that we're witnessing a new phenomenon, a phenomenon that is about President Trump and his administration, or if not just about President Trump, at least about recent politics and about the way in which political polarization in Washington has led to dysfunction, with Congress unable to act and the president acting in Congress's stead. So mostly in our book, we want to urge folks to resist this temptation of thinking that what we're witnessing today is a new phenomenon, because we think that the roots of the president's power over immigration policy are really much deeper than the partisan politics of the moment. And we think that understanding how we got here is really critical to charting a productive way forward. And so the first half of our book is really an effort to tell the story of how the president came to stand at the center of immigration policymaking. Now, the roots of that story are really very old, because since America's earliest days, presidents have played an important role in shaping immigration policy. In the 19th century, immigration policy was, you know, quite literally made through treaties that were negotiated by presidents with foreign nations. And those days are gone. You know, during the 20th century, Congress created an enormous and an enormously complex set of immigration statutes. Yet over the course of the 20th century, in fact, partly because of Congress's creation of this enormous code, our system of immigration regulation was transformed in a way that really cemented the president's central role. And in our view, there were really three interlocking developments that contributed to this change. The first was the rise of deportation in the 20th century. You know, the earliest federal immigration statutes often lacked deportation provisions altogether. And immigrants in general who came to the United States and were admitted were welcome to take up residence and remain for as long as they wanted to. Today, the opposite is true. You know, today, the grounds of deportability in the federal immigration code are incredibly numerous, and essentially all immigrants' right to reside and remain in the United States is contingent, under threat of being taken away. And that makes migration today to America much more probationary. So the second change that complemented the rise of deportation and the turn of our immigration system to a more probationary model was the explosive growth of an enforcement bureaucracy that could back those deportation rules. When the federal government first started to restrict immigration, it initially built an enforcement apparatus largely around the ports of entry, screening people at seaports. There was little enforcement along the land borders. There was no border patrol before 1924, for example, and really minimal enforcement around the nation's interior. And that world stands in stark contrast to the world today, where the Department of Homeland Security, which has the authority to enforce federal immigration law, has a budget that dwarfs the budgets of all other federal law enforcement agencies combined, and has resources significant enough during the Obama administration to deport upwards of 400,000 non-citizens every year. That's a huge number. It's more people that are incarcerated in the entire federal criminal justice system. So you had one change, the rise of deportation, which was legal, and a second, the rise of the enforcement bureaucracy, which was bureaucratic. And those legal and bureaucratic changes collided with a demographic change in the final third of the 20th century. And that demographic change was a rapidly rising rate of unauthorized immigration to the United States. And the causes of the rising rates of unauthorized immigration from about 1970 forward are complicated and contested to this day, but the consequences of those rising rates are really clear today. The consequence was that it left us with a world in which roughly 11 million non-citizens are living in the United States in violation of immigration law. That's nearly half of all non-citizens living in the US. And that means we effectively have an enormous shadow immigration system that stands alongside the formal one. That shadow system puts the president in charge because the intricate, complicated statutory code that Congress has erected becomes less and less important. What matters more are simply the enforcement choices made by executive branch officials, decisions about whom to enforce against, when and where. And those enforcement choices are ultimately supervised by the senior leadership within the Department of Homeland Security and ultimately by the president. And thus, not through an express statutory delegation, but instead through the creation of this enormous shadow system, Congress effectively gave the president enormous power to shape immigration policy in America. Now, this de facto delegation isn't the only source of the president's power. There are other sources like express delegations of emergency authority that we see in President Trump's ban on migrants from majority Muslim countries. And we can talk more in the conversation about those express sources of delegated authority, which we think are also important. But we think this key structural feature, this creation of an enormous shadow system, is a crucial fact that we all need to understand in order to make sense of the way that immigration policy looks today. So let me stop there and turn it over to Cristina to talk a little bit about how we should feel about this state of affairs.
Thanks, Adam. And thanks so much to David for the invitation and to Roger for the introduction. And Hiroshi, we especially appreciate you taking the time to be our commentator. So I'll pick up where Adam left off and think through, which is what we do in the second part of the book, how we should think about this system, how we should evaluate the shadow system and the president and executive branch's power over it that arises as a result of its existence. And we begin from the premise, and in the book we make this clear, that if we think that the Trump administration in particular has abused this power, or that this kind of power in the hands of a president is dangerous, we don't actually think that the proper response is to assert strong claims against the presidency or to declare that the presidency is out of control. This is an argument that is easier to make now than it was 2 weeks ago, or at least we feel less stressed when making the claim. But it's a general argument about how we should think about the forms of power and control that should be in place in light of the rise of the shadow system. And in many ways, the import of our historical account is to show that presidents have long looked for ways to advance their immigration agendas through the bureaucratic and legal systems over which they preside, and that our objective should be to understand when and why strong presidential power is actually constructive and needed. And then instead of making strong claims against the presidency, identify the laws and legal structures that can be exploited for abusive ends and work to reform them. And this agenda is as much a political one as it is a legal one. So our primary normative argument is that given the shadow system's existence, we actually need presidential power and control to tame or bring humanity to the enforcement system, that it is presidential control that is the only hope for accomplishing that if we keep the shadow system constant. But we should always be thinking about how that control can be used responsibly. And with a president like Trump, that might be an impossibility. But now there's in fact an opportunity for recommitment to thinking through this kind of internal reform. And the most important observation that we make, and this comes from doing a fairly elaborate case study of the way the Obama administration used high-level presidential control to try to manage the shadow system, is that it's first vital for a president to articulate enforcement priorities, for high levels of an administration to articulate enforcement priorities that correspond to their immigration agenda. And then, and this is just as important because the priorities cannot be realized without this, use that power to supervise law enforcement agents and the law enforcement bureaucracy in order to advance those priorities. It's important also to understand that exercising bureaucratic control of this sort actually requires strong political will. And one of the lessons from DACA is that it required high-level intervention to really shape the system to reflect enforcement priorities that operated to extend relief and to temper the reach and frankly cruelty of the shadow system. And I think one of the questions for the new administration is there actually the kind of political will to try to remake the bureaucracy that very clearly existed during the Trump years, where Stephen Miller and his allies throughout the government exerted a kind of force that bent the bureaucracy to their will. It has to be a political priority in order for bureaucratic change to happen, but the two work together to shape the nature of the enforcement system. Now, this, of course, this approach means that with a president like Trump, we may wind up with enforcement priorities we abhor and a reshaping of the bureaucracy in ways that we would object to. But we ultimately conclude that leaving these fundamentally political choices and the way to effectuate them in the hands of a semi-militarized law enforcement culture that characterizes ICE, which is what we focus on, but also could be said about CBP, would be far worse over time. So that's the first way in which we think about how to manage the president's control over the shadow system and the agenda that we would articulate for the control of it in a way that has a chance for introducing humanity into the enforcement bureaucracy. And we link it in ways to other statutory regimes where the articulation of enforcement priorities and the political will to actually make them real through the bureaucracy and enforcement choices can substantially shape the domain of the law. Criminal justice and civil rights are probably the two best examples of this. But then we turn our attention in the second part of the book, or really towards the end of the book, to explain that our ultimate aspiration is to bring the shadow system to an end altogether. So it's not enough to say, given the shadow system that is the product of the historical, the interaction of those three historical threads that Adam described, it's not enough to acknowledge it and think of ways to manage it. But instead we offer a vision of a system where there's less discretion than the shadow system entails in the hands of the executive branch. Because even as it's important to defend and conceptualize political control of law enforcement, if the zone of discretion is too large, then it's becomes a policy domain where the dysfunctions or undersides of discretion have too much room for expression. So even, for example, a well-intentioned administration that would seek to temper enforcement through a priority regime that is implemented through bureaucratic controls still has to preside over a mammoth system. And Adam underscored how large that state capacity is and has become, especially since September 11th. And so even concerted political effort to try to shape it will still give way to the operation of the system and to a range of enforcement choices and enforcement-driven policies in the way the system operates, regardless of what the political principles, even the president's views are of how the system should operate. And because Adam and I share a set of commitments that we articulate in the book that are in tension with the persistence of this large-scale discretion, the ambition ultimately has to be to bring the zone of discretion to shrink in, to bring the shadow system to an end. We spend a fair amount of time talking about what we think those undersides of this discretionary regime are, and they would be familiar to people who follow immigration law and policy. And they stem from the concept of the probationary system that Adam articulated at the outset, but that the probationary kind of framing of the immigration system mapped onto a shadow regime where it's all about the enforcement choices of the executive, makes the system into one that is effectively one of social control and opens up the possibility of domination by the government of immigrant populations. Even DACA is a contingent status subject to political whims and the decision to end discretionary decision-making. The threat of deportation, which hangs over people without status regardless of these relief programs, makes it difficult to plan and invest. And deportation is itself enormously destabilizing to individuals and the community. And we draw on the work of sociologists and others to underscore the picture of this system as one of domination that, given its size and character, ought to be tamed and essentially eliminated. Now, obviously, doing something of that sort, or perhaps it's not obvious outside of the legal context, but taming the enforcement logic of the system, the way in which our system as it is constructed drives immigration policy through an enforcement lens, first and foremost entails adopting a legalization program, which is the only way to bring the shadow system to an end. And this, of course, requires legislation. And so the results of the election might mean that this part of the book remains as much aspiration as it was when we were writing it, as opposed to something that is achievable given the likelihood of divided government for at least the next 2 years. But it nonetheless remains important to think through what this agenda would look like in anticipation of openings in the legislative process. And it's not enough to adopt a legalization program. We're also very clear that it's important to put the right tools into the law that enable the executive branch in particular to prevent the shadow system from reemerging. And there are a lot of examples that we include that have been part of immigration reform debates for a long time, such as reviving statutes of limitations on deportation grounds, the possibility of creating rolling legalization programs that are administered by the executive. And it's this latter concept that we want to also turn into a larger frame for thinking about immigration policy, and ultimately to use the opportunity of the book to say that we've learned things about the role of the presidency and the executive branch in the formulation of immigration policy. And even if we think that it's vital to undo the enforcement logic, there are other forms of executive power that are constructive and dynamic and essential to ongoing governance that is effective. And tools that sound in that are ones that ought to be incorporated into the law in order to prevent humanitarian disasters from arising in the first place. Again, and this is the note I'll end on, this is a political ambition and requires mobilizing at least enough interest group pressure, but possibly also a public opinion that rises above the level of priority number 13 on everyone's list for legislative reform in order to be achieved. And so even though we end the book on an optimistic note about the possibilities for reform in a system that is more dynamic and less dependent on a coercive enforcement, it remains the case that we have to continue to think about how to tame an enforcement logic without the transformation of the system. And in the event that the kinds of dynamics that Adam described at the outset are deeply embedded in the political economy of immigration and may well continue despite who's actually in charge at the level of the presidency. So I'll leave it at that, and maybe just also make one more note, which is that neither Adam nor I said anything about the courts in all of this, and the courts play a minor role in the book and in the account of the exercise of power over immigration, but they remain an important part of the system. And whether we can expect or hope for courts acting as ongoing backstops against the worst abuses of presidential and executive power, regardless of who is in charge of the executive branch, is a conversation worth having and one we'd be also interested to entertain. So I'll leave it at that, and then I guess turn it over to Hiroshi, right?
Okay, excellent. Hiroshi. We're not hearing you, Hiroshi.
Yeah, so I've been looking forward to this event for a long time. So it's really great to actually be all in the same room, so to speak, here. Yeah, I just want to say, first of all, I mean, it's a real honor to comment on what is really, I think, a very important book in a lot of different dimensions. And it's been especially nice to see the project evolve over time. And as I think about it now, over multiple administrations, and I'm sure you feel like you're trying to hit a target that keeps morphing and evolving in ways. I remember going to a workshop on a draft of this book that was in what we now think of the latter days of the Obama years, and thinking about what could happen in the 2016 election, which I guess was obviously a big change. So there's so much to talk about here, and it made me realize that your task in telling us about the book in 20 minutes is much more daunting than even my commenting on it in 10. I think that there's so much to talk about, and I should make clear that so much of it is both in just entirely new material, and then also new perspectives on a lot of ways that many of us have thought over the years. That's equally valuable, and so I really appreciate that. So I'm going to be selective and focus on one aspect, really, in the interest of time here. And what's interesting about this as sort of a meta comment on my own comment is that it's going to be different from what you said in introducing the book. I'm going to talk about parts of the book you didn't actually talk about that much, but I think are really important. And I want to lift them up. And for those of you in the audience, we didn't do this by pre-arrangement so that I would talk about what they didn't reach. But I do want to use it as a perspective to talk about what you do reach. Okay, so the book. I mean, if you really were to break it down into its conceptual architecture, obviously grossly oversimplifying it, there's kind of a 2x2 grid that I have in my mind. One is time, and the other is direction. And the time dimension is how we get here, right? I mean, it's the past and the present, and the direction dimension. So the other, whether it's vertical or horizontal, is the inward facing, the internal part of the book, the part that focuses on interior enforcement, on documentalization. But I also think that you do a lot of really important path-breaking work on the external facing part of this. And so, and it's been something that I think you uncover in novel ways, which is starting with the so-called parole power. So the parole power is the power granted with certain constraints. Often those constraints have been ignored, but they've been allowed. It's been a way for people to get into the United States without formal admission. So this has been used in many refugee situations. And Adam and Cristina do a lot to explain this as a source of power. And then more recently, and alongside the parole power, which is the quasi but not really admission power, subject to all kinds of political and legal constraints, we also have the opposite side, which is the power to block the border, which is the suspension power. And we see that in the ban on travel from certain majority Muslim countries. It's been used much more aggressively by President Trump, and so that's kind of the 2 by 2 grid. And you've just spoken now about the internal part of this, right? And I think that you do a lot to. I mean, the internal mechanisms have gotten a lot of scholarly attention, but I think you reorder this, you reorient this, and you look at this from a perspective that has. You look at prior work that may have been focused, for example, on the undocumented population, and re-examine it from a more institutional lens of the presidency, and that's really important. And so, in your remarks, you talk about the enforcement and the internal facing. You have one chapter basically on the outward-facing piece on parole and suspension power, sort of the what do we do about things happening outside the border when they reach the border or could reach the border. And you have several chapters, so you devote more time to the enforcement part of this. And this is where you talk about probationary status, the zone of discretion enforcement. I think what's interesting to me is and this is not so much a question, maybe as a comment, but sort of what the relationship is between the internal and the external. In other words, you just focus now based on, I assume, time constraints on the internal, but the external part has gotten, I think, even less attention by scholars. And it divides into these 2 categories of the parole power to quasi let people in and the suspension power to keep people out. So the reason I think this is interesting, well, it's interesting to me, and I think it's important, is when you shift from the how we got here in the past and present, that part of that half of the 2 by 2 grid, but to the forward-looking part. Because a lot of what you're talking about, and it makes sense to me, everything you just said about the forward-looking part, minimizing the zone of discretion, legalization programs, reducing the potential for this executive branch power in the president or in agencies to be used in an abusive way, especially if the abuses cannot be uncovered and remedied. That makes me ask this thought experiment question: is suppose we did those things. Suppose we had legalization programs. Suppose we had more of a closer connection between law on the books and law in action. Then what would the presidential power be? And the reason I ask this question is, what happens to the outward-facing part of presidential power at that time, at that moment? Is it the case that no matter what we do with enforcement, and no matter how much we bring the rule of law to that, and no matter how much we think about this in terms of a matter of reducing, what you're calling de facto delegation and the abuses that it may, and we accomplish that. Here's the question: what is irreducible about the parole and suspension power? Is that more fundamental to the president immigration law than the enforcement part of it? The future of the external piece of this, what's going to happen with that? And I say this because I think a lot of what's happened, this is a general comment about maybe the field of immigration law and policy, is that much of the action, I suppose you could say, both intellectually and politically, has been focused on the undocumented population, and it should be there, right? But what we're seeing is a shift in politics that centers not only the undocumented population, but also what happens more globally, more externally. What happens when tens of thousands, hundreds of thousands of people come from Central America or go to Europe from Africa or Syria? And are we going to see in the future, not now, but maybe 10 or 20 years from now, sort of something that is much more where if you were to write a book about the president of immigration law post the enforcement apparatus era, would it then be a book about the president of immigration law, and then would the attention come to the parole and suspension power as somehow more irreducible? And so I'm wondering how that informs how you think about the future and how you think about proposals, because part of my reaction was I actually agree with just about everything you say about the internal, how to move forward on the internal side, but I also wanted to hear more about how you think about what are the checks and balances on the external side? I mean, Adam, you started by talking about the days of treaties, right? And you made a comment which I don't think you quite said this. I won't really attribute this phrasing to you, but it sounds like, well, those were the days of yesteryear. But it almost feels like now what really matters in migration might be what our relationship is with Mexico. What the EU's relationship is with Turkey or the Horn of Africa, or with Jordan, in sort of taking in, transit countries taking in a more supported way people who flee. What do we do about climate change and the migration that forces? And if that's where the foundational issue should be, then I feel like, and then maybe the right answer is another book, right? There's always another book, but it feels like if I look at the architecture of the book, I'm interested in what there is on the external future. Is there a revival of the treaty power? If that's where the action is, do the responses to have a more responsible presidential and executive power over immigration law, are the responses to the inward-facing problems going to be the same as the problems to the outward-facing problems? I don't know the answer to that question. By the way, this is just in the 5 seconds I have left. I just realized that in some ways, what I said about this book is very similar to something that Cristina said when she reviewed a book of mine 12 years ago, which is this. This is really interesting internally, but what about how does it fit into the world? And I think that was a very fair criticism, Cristina, that you made of the book at the time of my book. And so I feel like I hadn't been waiting 12 years to say this. Don't worry about this, but it just occurred to me as I was talking, like, oh my God, this is really very similar. Anyway, so that's 10 minutes.
Okay, terrific. Thank you so much, Hiroshi. So why don't we give the floor back to Adam and Cristina and then open up. So people interested in raising questions, please either send me a question in the chat or raise your hand via the Q&A. Okay, Adam or Cristina, whoever wants to go first.
I'll start. And I first want to say that it's nice, Hiroshi, 12 or 14 years later to still be in conversation with you, and that Hiroshi is responsible, certainly for me, and I think probably also for Adam, engaging immigration law and entering the field, because we met him very early in our careers, and he's a fantastic mentor and nurturer of young scholars. So it's nice to be having this conversation with you. And I thought what I could do is just make some observations about the external, and then maybe the combination of them will begin to answer your question. So the first is that when I began teaching and writing about immigration law, I thought that the claim that there was some necessary relationship between immigration and foreign policy was dramatically overstated. And you see it used in, my first entry point to it was the rhetoric in Supreme Court cases about how this is about the United States relationship to the world, and that understanding of the immigration powers helped to empower the president and also create these complex doctrines of deference that also relate to the national security dimension of immigration. But I think through the work that Adam and I have done, and especially with respect to Chapter 2, which is the chapter that you're invoking, but also the work we did on the Gentleman's Agreement and the Bracero era, I've come to actually appreciate that is a deep connection in ways that both obviously have empowered the president because of the treaty making power, but also because many of the challenges that lots of the presidents whose policies we discuss arise because of foreign policy interests by the establishment, but also foreign policy pressures and pressures from the outside that the United States does not directly control, or that policymakers cannot directly control. And in some ways, unauthorized immigration, which is central to our domestic story, is also a reflection of that. And that, to me, from both a reform and a power point of view, pushes in the direction of, and I think this is part of what you're interested in, Hiroshi, a more holistic understanding of what it would take to undo the shadow system and to make an immigration policy that is oriented towards humanitarianism and integration and pursuit of the national interest. And that is a concept of immigration policy that deals with things like root causes and that deals with the reasons why people migrate. And that cannot be separated from the laws that the United States adopts. Certainly the power that Adam was describing, the suspension power, was added to the immigration code during the Cold War out of a fear that there could be migration-related security threats that would arise during that era. But I think the view is now, and our view is that those kinds of tools need to be reshaped into ones that actually both address the reasons why those threats might emerge, but then also provide an executive branch with ways of addressing them that are constructive and not just oriented towards exclusion. So that's the first point. And the second point I make, and there's a lot to say, and I'll let I want Adam to hear how Adam reacts to what you're saying, is that the other way in which the parts of the book that you're talking about, what we say about how presidents have used the parole power to construct our refugee system, or have used the suspension power to take strong political stands, reflects something that's also true about the domestic system. And so is something that pervades, I think, just the exercise of presidential and bureaucratic power generally, which is the possibility for bureaucratic dynamism that an administration with the political will to do something like admit tens of thousands of Hungarians or admit hundreds of thousands of Cubans without the legal channels to do it will find tools that exist, some of which are not intended for large purposes, but that nonetheless are present to make good on those promises. And I think that that is just interesting observationally, and it's interesting to us because we're defending a concept of dynamic executive governance that should be better employed, which helps to justify, which may be counterintuitive to some, more delegation to the executive branch as opposed to less, but just delegation of certain kinds of tools. But it's also, I think, important because it demonstrates that that the way that the executive branch uses the tools that exist will adapt to the crises that that the country faces. And it's a reason why the executive power both has an advantage here, but is also an important kind of power to understand and not to fear, but to try to mobilize. And I think it's unclear exactly how those adaptations will occur. I think we can all posit that the United States is going to face threats, that's the wrong word, not threats, but pressure from refugees that are produced through climate change. I mean, that's something that is on the horizon, but we don't know exactly what the means for addressing that are. But that's precisely why you need an adaptable system, and why executive power is a useful way of thinking about managing both the outside and the inside. So that's just a collection of thoughts based on that challenge that you issued, Hiroshi.
Okay, terrific. Adam.
Yeah, let me just, I agree with everything Cristina said. And also want to take the time to say to Hiroshi, as Cristina did, thank you, because it is true. It's absolutely true that the only reason I'm standing here today is because of you. Your work as a mentor for all of us has been amazing. And even on this project, as you said, you gave us tremendous feedback when we had this book in draft, and the book is so much the better for it. So let me just say two more things about your super interesting thoughts about the parole power and the suspension power. Let me say one thing about power and one thing about needs, maybe, or the changing world. On the question of power and your sort of seductive idea that maybe there's something more irreducible about the parole and suspension powers in the hands of the president. I do think it's true. We're obviously written a book about the separation of powers effectively in immigration policy. And one thing we've learned, which is a lesson we all probably relearn in many domains, is the way that the the power dynamics operate are going to be not just domain specific. Immigration law looks different than environmental law, but also differ in different parts of a domain. And I do think what we observe in chapter 2 is that, efforts to discipline the parole power, and I'm gonna speculate that potential future efforts to discipline the suspension power are gonna run into serious problems. On the parole power side, we've seen historically, like Congress repeatedly tried to rein in the kind of large scale exercise of parole authority by presidents, and presidents just repeatedly ignored Congress. And what that created, in a way, I think has exacerbated some of the problems with the system, is what Congress was kind of effective at doing was refusing to regularize the status of people who were paroled ultimately, and limiting access to things like permanent residency. So when the Refugee Act of 1980 gets written, yes, what it does is restricts in some way the domain of policy space where people are going to have a pathway to permanent residency because they have to qualify as refugees. But they didn't really ultimately, that act didn't effectively restrain the president's power to let more people in. It just meant that the people who were let in were more likely to be in an irregular status in a kind of permanent way, which was true for the Mariel Cuban boat lift, for example, and for others. And so that to me seems slightly dysfunctional, right? The kind of constraint Congress is able to enforce against the president's exercise of power is the one that just kind of exacerbates the problem in a way. On the suspension power, though we haven't seen efforts to restrict it legislatively, I suspect we'll run into some of the same problems, because what you can see historically is that the president in the executive branch has other tools it can use as kind of substitutes for formal suspension authority to push the border out. Like in the Caribbean Basin, interdiction policy is a kind of policy substitute. I think an important reason why we never saw, large-scale suspension exercised at the border was because we saw it exercised through interdiction policy. And, interestingly, it was technically, a declaration of suspension power when we engaged in interdiction in the Caribbean Basin. And today we see in other contexts, like when it's not, when it's not open ocean, but it's land borders, well, we negotiate with Mexico to persuade the Mexican government to increase its enforcement efforts along its own southern borders to reduce the flow of people who can make it to our southern border. And so those kinds of substitute vehicles for making suspension-like policies, I think will make it pretty difficult to rein that power in. So that's on the question of power. I think I agree with you that there's something that's going to be difficult to get at there. On the question of the changing world and needs, it might also be true, and this is definitely more speculative, but if you think about the kind of epics of American immigration history, we spent a really long time, an epical period, where the policy terrain and the world that so many people thought about was centrally defined by the kind of bilateral relationship between the United States and Mexico, and very, very high rates of in-migration from principally Mexico. And a lot of policy responses were designed around that. And that world is kind of mostly in our past. There's a real realignment happening where, while there's significant rates of immigration from Central America, it's not principally from Mexico any longer. And so that does suggest that we might in the future, in the not too distant future, be in a world where either unilateral responses to, to policy issues that arise just because we're a giant receiving state, or even bilateral arrangements because there's really one sending country that's sending us many, many people, are going to have to give way to much more multilateral arrangements in order for the US government to take actions that it sees in the interest of the United States. And so, maybe we will come full circle, right? It might be that like we began in a 19th century world where so much of immigration policy was externally facing, we transitioned through a world where it became very much like other domestic policy areas, and maybe we'll ultimately transition back to a world that looks much more multilateral.
You gotta unmute, Roger. You're on mute.
Sorry. Hi. Okay, so thank you very much. So we'll switch now to questions. So in the interest of time, I guess I'll ask only one author to respond, if that's okay. Although if you feel compelled, please jump in. So the first question is from David Fitzgerald. How would you rate the degree of presidential power in the US over immigration policy compared to the power of the executive in other major countries of immigration?
I'm not a comparativist, so I'm not going to give it a answer to this question. Christina, do you want to take a stab at it?
I'm not really a comparativist either. But I think that this is speculative, that a presidentialist system will look very different in this regard than a parliamentary system, and that a lot of the dynamics that we are describing are characteristic of other policy domains in the United States, and are a feature of a presidentialist system where you have a separate branch of government. And the way in which I think it's different, because obviously other immigrant receiving societies, the one I know the most about other than the United States is Canada, have ministries and executive officials and a concept of executive power, but there's less likely to be a divergence. There's not a divergence between the person in charge of the government and what is happening through those ministries. They're one and the same, but there's still obviously a disconnect between what political officials generally seek to do and what the underlying law might require them to do. And so you see similar kinds of debates about the scope of detention, for example. We haven't used that word yet, but that's part of the enforcement logic that we're describing. Whether due process is afforded by executive officials during deportation, and whether, which structures of government should be involved in making decisions about who can enter the country and not. In Canada, that's more likely to get channeled through federalism than in the United States. So we do talk a lot in the book about the role that federalism plays in its relationship to presidential control. And so there's both a way in which presidential priorities loom large in an American system and shape the system in a way that's not true for a parliamentary system, but that the concept of enforcement is universal, and the same sorts of forms of resistance to enforcement as well as pressure to enforce exist as the result of political cultures, in all immigrant receiving countries. So that's a shot at the answer to the question. I'd be interested if David himself has some insights as someone who's more comparativist than we are.
Okay, terrific. A question from Jorge Navarro Lucio. How do you approach the concept of catch and release and the policy of remain in Mexico? Is there any room for a bilateral agreement with some degree of humanitarianism?
That's a great question. I mean, it could be several different questions. So I'll sort of restate what I think the question's asking to make sure I'm answering the question properly. So obviously there's a bunch of different strategies that our government has used to try to manage the increasing rates of asylum seekers, particularly along the US-Mexico border. One approach, which has somewhat pejoratively been labeled catch and release, is to initially screen folks who present themselves at ports of entry or are apprehended between points of entry for asylum. And if they pass what's known as a credible fear screening, right, so have some plausible claim to asylum, then to grant them, to go back to what Hiroshi was talking about, grant them parole, right? So to use the parole power to actually release them into the nation's interior for the pendency of their immigration case, while the immigration courts figure out whether they in fact should receive asylum. In the last 6 years, we've seen two other strategies. One is to not release people on parole, but instead to hold them in detention facilities for the duration of their proceedings, right? That was a policy that began to be used much more widely during the final couple of years of the Obama administration, and then continued and adopted even more aggressively during the Trump administration, where non-citizens who satisfy the traditional criteria for release on parole, even after they've made it through their credible fear interview, were denied release and were held in custody. That's possible in part because parole is, as Hiroshi noted, it's a discretionary act. It's not a bail hearing. It's not in front of a judge. You don't have a right to release if you demonstrate that you're not a flight risk or a danger. It's discretionary until the government in its discretion has started to deny it at much higher rates. So one possibility is hold people in detention. Another possibility, which the Trump administration pursued, is don't let people in. Force them to pursue their asylum cases while they remain outside the United States and Mexico. Now, both the increased use of detention and the remain in Mexico policy are justified principally on the argument that releasing people into the interior of the United States guarantees that they won't show up for their hearings and that they'll pose a threat to the community. And I think, while that's what's driven these policies, I think that there isn't actually evidence to support the need for such high rates of detention or something like the Remain in Mexico policy in order to ensure people's appearance at their asylum hearings, nor is there significant evidence that people who are asylum seekers who've made it through the credible fear process and are awaiting their hearings are significant dangers to the community. And so, at a small scale, you've seen alternative ideas, like other forms of supervisory release that have been very effective when implemented on a small scale by the Department of Homeland Security. And so in a Biden administration, I think one potential policy opportunity would be to respond very differently to arriving asylum seekers by pursuing on a much more broad scale these alternative forms of supervision, which could provide people the ability to live their lives in American communities while they pursue their asylum claims, rather than sitting in jails, detention facilities, or being forced to remain in Mexico.
Okay,
Christina, did you add anything to that?
Okay, so I am going to pose a question sent to me by Sophie Kosmacher, and then I'm going to build on that. So her question is, I'm curious about the degree to which you think political gridlock influences presidential power. Does it track that historically presidential power wanes when Congress is working efficiently and waxes when it's stuck? Now, in adding to this, I really want to build on an aspect of Hiroshi's comment, because your emphasis really is on the punitive controlling power of the executive, but Hiroshi highlighted another dimension, that is the way, the really historically transformative way in which the president used discretionary power for expansionary purposes. I mean, very large populations were led in via the parole power, and the entry of those populations, well, their access to legal status then generated further legal migration. And so, and isn't that true more generally? I mean, you kind of presented undocumented immigration as an inevitability, that given its presence, well, it was inevitable that the policies that would be pursued would be punitive. But one could well imagine that the president could have decided, no, what we're going to do is we're really going to enforce employer standards. We're going to make employers really inflict significant pain if they're going to employ undocumented workers. And a whole series, I think, of other possible instruments were available. To take another example, so I'm teaching a course on refugees, and of course we read through the Geneva Convention, and I was reading the article on naturalization, but for the first time, I want to bring this up on the computer. Let's see if I can do it quickly without a disaster. Well, in any case, one of the things at the end it says, and that naturalization should be made available at the lowest possible cost. So instead of charging refugees, so this is statutory, instead of charging refugees $680, it could be $0 or $25. And one could, yes, INS, sorry, whatever, USCIS, it's a self-funding agency, but you could triple the charges on all the business immigrants, and this is all within the capacity of the president. So isn't there an imbalance in your argument? That is, you note the expansionary potential, but then you push it to the side and focus on the punitive as if that's the only possibility.
So Adam, I can take these questions. So I think that one of the goals of the book, to answer Sophie's question at the outset, is to underscore that the scope of presidential power over immigration law is not the result of our polarized politics, which is to say that it is the product of this system of de facto delegation, the shadow system that Adam started out by describing, that evolves over the course of a century. And so regardless of who is in charge of each of the branches of government and whether we have divided government, if we have a system that looks like the one that we do now, and its arising precedes our hyperpolarization of the last decade, or however many years you want to describe as it encompassing, you have a system that empowers the president and the enforcement bureaucracy and the executive branch. Now, I think we're not necessarily equipped to answer the question of whether the feeding of that system by appropriations by Congress, the refusal to adopt a legalization program and otherwise address unauthorized immigration, the expansion of the grounds of deportation that helped to feed this this system of presidential power is itself a product of polarization, or is exacerbated by polarization. That certainly is true on some level, that the inability to reform the system where you might reduce the power of the president over the enforcement regime must be related to the way in which the parties increasingly have moved away from each other and hardened with respect to their views on different sides of the spectrum on immigration. That does not mean, however, that polarization doesn't affect what you see in any given administration, right? So given divided government, President Biden is probably more likely to engage in executive actions earlier to a greater extent than he would if he thought he could get legislation through Congress. Remember that during the Obama years, the administration tried initially to reform the law through legislation, and DACA did not come into place until 2012, 4 years after, 3 or 4 years after the president was elected, when it was clear that legislation wasn't going to succeed. I mean, there was an attempt a year after that, and so the polarization certainly affects those dynamics. If you're looking at a day-to-day kind of level, if you're looking at discrete periods in time, but generally speaking, what we see, the president's power is not the result of polarization. To address Roger's question, I think it's a complicated one, and we try to take kind of two positions on discretion that might seem contradictory. The first is that our goal in thinking about how to manage the shadow system is not to eliminate discretion, right? One view, and we haven't really talked about the constitutional theory piece of this, is that the president is usurping legislative power by exercising discretion in a way that seems to create rules or create policy, something like DACA. But our view is that discretion is actually vital in a system where all these choices have to be made about whether to enforce the law. It's going to be exercised at the line level by line agents. And so it's vital that higher level officials who have a holistic systemic purview and are not motivated primarily by enforcement, but by a mix of considerations, have discretionary powers or powers to shape the system through discretion. And I also think, Adam, in response to Hiroshi, said something that's important, and that is that there is something irreducible or inescapable about the president's use of discretionary power. Every time Congress tries to eliminate it, historically, the president finds a way of exercising it to advance an agenda that may be political, maybe humanitarian, whatever it is. And that is within limits, right? It's not that the president is making up the law, but it's through exercising discretion and innovating that the law gets pushed forward. So descriptively and normatively, you're right that you cannot eliminate this from the system. We don't want to eliminate it from the system. But what we're arguing instead is in the very, I guess, the last chapter of the book is that the way that the shape that discretion takes now, and the fact that the president's power arises through the decision whether to detain or to release, whether to arrest or not, whether to remove or not, creates an untenable system for millions of people in the United States that's inconsistent with the very same rule of law values that the kinds of discretionary control that we are defending also seeks to advance. And so a perfect world is one in which the shadow system does not exist at all, but where the executive branch still has the ability to respond through discretionary actions to changing dynamics in order to ameliorate the effects of the law or inject humanitarianism into the law. So I hope I've squared the problem or resolved the tension that you see in that way.
Okay, let me pose one more question. Isn't the goal, so Adam, did you want to respond or can I go ahead? No? Isn't the goal of these strategies for keeping asylum seekers outside the US not just to prevent immigration or danger to the community, but to prevent them from forming meaningful and stronger social ties with residents in the country, which will then make it easier for them to have easier for them to stake a claim to remain in the country and harder to deport/remove them? It seems to me as if the danger to community argument is a bit of a red herring, and you can rethink this as a struggle over how many social ties prospective immigrants have with inhabitants of a country.
That's a good question. And it is, I mean, I guess I didn't mean to suggest that those were the only two potential reasons why the government might adopt the policy. I think they're the two main legal arguments that the government makes, to advance the detention policies and the Remain in Mexico policies. And if we're adding this one, which is about, kind of preventing ties, I guess I'd add a fourth, which is not just to prevent people from being here and developing social connections, but also to deter other prospective migrants. I think part of the very design of the detention policies, the Remain in Mexico policies, the family separation policies by the administration is to send a message to tell people that it'll be very difficult and your life will be disrupted and awful in all kinds of ways. You'll be stuck in a jail. You might have your children taken away from you. You might be stopped at the border and forced to remain in Mexico, which is not the country from which you initially immigrated and where you might not have any connections. And the goal is just to persuade other prospective migrants not to make the journey. And so I do think at that level, there's a long history of American immigration policies being adopted either to deter people who might want to come or to make it more difficult for them to develop social connections in the United States. Our temporary worker programs that we have on the books, for example, are pretty openly designed to do that, to structure the labor markets for those workers in ways that reduce their abilities to develop connections and ties. Now, interestingly, I will say in the context of asylum seekers who are paroled, remain in an asylum-only removal proceeding where it is difficult for them to raise other kinds of claims to belonging. And in fact, while in a way, what we might think of as the moral claim people might make, if they've waited 5 years for an asylum hearing, they've now spent 5 years in the country working and developing social connections, the moral claim at that point to be permitted to remain may be very strong. Their legal ability to raise that claim is actually not significantly affected by the fact that they've been paroled. But that's true for them. It's also true, a similar kind of category of people are people who are here on temporary protected status. People who have been in the country for decades on temporary protected status, the moral weightiness of their claim to be permitted to remain at this point because they've just built entire lives here is quite strong. And not even built lives in the shadows, but built lives with the explicit acceptance of our government, of their presence in the country. And yet, the moral weightiness of that claim doesn't automatically kind of mature into a legal claim that can protect them from deportation. And politically, I guess if we got morality and legality, we should talk about politically. Politically, interestingly, my rough read on the politics of it is it also, in the TPS context is different, but in the asylum context, many Americans don't understand that the situation of many asylum seekers is not that they are actually recent arrivals who have been pursuing their claims, but that they've been here for years pursuing their claims. And therefore, I don't think that the parole policies previously really changed the political dynamics around asylum or the kind of legal right to remain for prospective asylees.
Okay, so let me ask one more question, then I think we will have to call it a day. This is from Rick Baldos at Oberlin College. How does the fragmented architecture of the US political system stymie policy innovation and limit presidential capacity to effectively effectuate sweeping changes in the US election regime?
I can take a stab at that, and maybe Adam also wants to say something. This is our final question. I think that we're both also professors of constitutional law, and it has become en vogue to talk about how our presidentialist system really stymies the ability to achieve lasting change, or even to produce public policy that solves social problems in a way that is responsive and immediate. And a lot of that has to do with divided government and with polarization, but it's also structural because of the divergent interests and powers of the legislature and the executive. And I think that that is clearly a dynamic in immigration policy making. And it doesn't even necessarily require divided government. It just requires the parties to be in opposition to one another, making it difficult to create the coalitions that are necessary to achieve lasting change. And I don't know that immigration is unique in this regard, but it does have this feature where there are a number of different interests and groups that have to, or it's come to be that they have to work in combination, engage in trade-offs in order to produce something that any one of them wants. And that makes the bargaining especially difficult. And that might just be a feature of modern regulation, but it seems very palpable in the immigration setting. And I think what that means is that in our system of government, you have a lot of tacking back and forth between entirely different conceptions of what the legal regime is supposed to accomplish or supposed to be. Some of that is at the surface, right? Or in the political rhetoric that presidents use, because as we suggested at the outset, beneath it, there's a lot that happens that's quite similar across administrations because of the size of the system and the nature of the bureaucracy. But that back and forth presents on some level for theories of the executive branch a problem. How can the law mean two entirely different things depending on which political party is in power? And that's part of the resistance behind things like DACA or some of what President Trump has tried to accomplish, the sense that it cannot be genuine or sincere because it's so different from what preceded it. But I think we're both of the view that that is precisely what the system enables, and then you can marshal legal arguments to defend them. But ultimately, it underscores the policymaking power of the president and the officials who are in charge of the operation of the system. And that is in part the result of the structures of government that you're describing, or that is part of the premise of the question.
Okay, all right, terrific. Adam, any final thoughts?
Nope.
Okay, all right. So thanks to Christina and Adam for joining us today and for writing such a terrific and stimulating book. And thanks, Hiroshi, for your comment. And so we look forward to seeing you one more time this quarter, next Friday, same time, same place, for a discussion of Lauren Heidbrink's book, Migranthood, and then starting again in January. Okay, everyone. So thanks very much. Great to see you. And of course,
Thank you.
Hey, bye-bye.
Take care.